All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Please be seated. Good morning. Ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the morning docket.
Thank you.
The first case on the 10:30 a.m. docket for Friday, May 10th, 2024 is appeal number 127338 in the matter of Eric M. Gamble, respondent, original action and attorney discipline.
Good morning, and may it please the court, Kate Duncan Butler appears on behalf of the Office of the Disciplinary Administrator, present and ready for argument.
Good morning, Christopher McHugh of Joseph, Hollander and Kraft representing Mr. Gamble. Mr. Gamble is here in person. Also present with us is Diane Belquist. We are present and ready for argument. Thank you.
Second case is appeal number 127196 in the matter of Carl F. A. Maughan, respondent, original action and attorney discipline.
Justice, may it please the court. Alice Walker, Deputy Disciplinary Administrator, on behalf of the Office of the Disciplinary Administrator, present and ready for argument. I anticipate requesting 3 minutes for rebuttal.
Our understanding is that Mr. Maughan has called the clerk's office to inform the clerk that he has experienced car trouble and is delayed, but expecting to be here before the end of the court session. So we will recall the case at that at some point. Whether it's when in the order of the cases, if he has arrived by that time, and if not, we'll proceed with the other case and move that one to the final slot, with apologies to Ms. Butler, who will have to argue back to back in that case. So not ideal, but I appreciate it.
Final case is appeal number 127337 in the matter of Darren R. Fulcher, respondent, original action and attorney discipline.
May it please the court, Kate Duncan Butler appears on behalf of the Office of the Disciplinary Administrator, present and ready for argument.
May it please the court, Todd Mulder on behalf of respondent Darren Fulcher, who also appears in person. We're present and ready for argument.
Your Honor, that concludes the docket for the week of May 6th through May 10th, 2024.
Thank you. I asked the attorneys and responded in 127338 in the matter of Eric M. Campbell to please come.
Madam Chief Justice, and may it please the court, Kate Duncan Butler appears on behalf of the Office of the Disciplinary Administrator. I would like to respectfully request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. This is an original proceeding in attorney discipline involving the respondent, Eric M. Gamble, who has been licensed to practice law in the state of Kansas since 2003. This matter comes today before the court under Rule 223 as part of a summary submission agreement. The parties have entered into this agreement in which they have stipulated to the facts, the rule violations, the applicable standards, and the aggravating and mitigating circumstances. It is the joint recommendation of the parties in this case that Mr. Gamble's license to practice law be suspended for a period of 6 months, but that suspension be stayed for 12 months probation. The probation plan is included in the summary submission agreement and can be found at Volume 1, page 252 of the record in this case. To summarize the facts underlying this case, a wife left her husband in Utah after a domestic incident and brought the children to the state of Kansas. Once in Kansas, in Wyandotte County, she filed a protection from abuse, emergency custody, and later a divorce action. The law firm that represented her was run by her sister, although there was another attorney of record primarily working with her. The husband hired Mr. Gamble for the limited purpose of challenging jurisdiction and venue. After joining the case, Mr. Gamble sent an email in response to a question about selling the marital home to the court and opposing counsel, in which there were allegations of venue and forum shopping and attempting to gain a home court advantage for the wife. Mr. Gamble then subsequently filed motions in all three of the cases. In the divorce, he filed a motion to strike and request for sanctions that included the home address of the lawyer's sister, whose law firm was representing the wife. He also filed what were styled as omnibus motions in the petition for abuse and emergency custody actions. These motions, the initial one, there were then two amended motions, were filed over the course of a few days. They requested extensive relief. Each was substantially similar to the other, pardon me. In those motions, he included the lawyer sister's home address. He also made unnecessary and objectionable remarks about the sister's shared extended family out of the country and attached newspaper articles regarding that extended family. He requested, after filing the second amended motion, the last of those three, that the court issue immediate relief. The court declined to do so. Eventually, the court had a hearing at which Mr. Gamble did not offer evidence apart from the citations to the existing record that were in those motions to substantiate these claims within his omnibus motion, and did not withdraw any of the statements made about the wife's sister, the lawyer. Ultimately, the district court found that Mr. Gamble included irrelevant information and inappropriate information in these motions that diminished the wife, lodged inflammatory attacks on the sister and her law firm without any legal purpose, and improperly accused counsel of forum shopping. The district court struck the objectionable material, denied the motions, and ultimately sanctioned Mr. Gamble. Mr. Gamble has stipulated in the summary submission agreement that this was a violation of KRPC 8.4 subsection D, which is engaging in conduct prejudicial to the administration of justice. The motions impugned the judicial process and created an unnecessarily adversarial relationship between opposing counsel without evidence to support the allegations, and it cost the court and the parties time and expense to handle that.
Counsel,
Yes.
I'm not questioning the summary submission, and I understand the respondent has admitted to these violations. But since we're here, I'm curious if you have how would you articulate the line between zealous advocacy that introduces material that a court is going to strike? You know, it's irrelevant, what have you, versus an ethical violation. The rule can't be every time you introduce material that gets struck, you violated the rule, right? I mean, you would agree with that, I
Yes.
presume. So is it just case by, like, is there an objective way to draw that line?
Justice Siegel, in this case, the district court ultimately found that much of this objectionable material was essentially ad hominem attacks, personal attacks on the law firm, the sister attorney. Also, the address of the sister attorney is personally identifiable information, that there was a way to advocate. If the argument was that the wife was living with the sister and therefore venue was improper, there's a way to advocate for that without including her actual full home address in a pleading. And so the question is not, is all irrelevant information going to rise to that level? But when it becomes, for lack of a better phrase, and I apologize, an overwhelming amount, a repeated amount. I believe the district court's ruling says that the sister attorney was mentioned 20 times in these pleadings. When it sort of goes beyond just, you know, this is tangential, but you can see the link to personal, I think that is when we are talking about an ethical violation. So as I said, the joint recommendation of the parties is that Mr. Gamble be placed on probation. It is our belief that the probation plan complies with Rule 227 because it is workable, substantial, detailed, protects the public and has adequate safeguards to address the misconduct. The probation plan is tailored to what happened in this case in that it requires Mr. Gamble to meet with a practice supervisor and then run pleadings and motions by that supervisor in high conflict cases to help identify what is zealous advocacy and what may be strategically too much, or may end up hurting the client because it is outside the ambit of what is being discussed in the case. Mr. Gamble, in his affidavit of compliance, explains that he has started supervision in July of 2023. He is complying with probation. He's been proactive in that his practice supervisor had an accident, but he has obtained replacement practice supervisor and has been complying with probation.
Maybe I'm getting ahead of your argument here a little bit, but can you help me understand the KLAP resiliency group activities and what that's about? I'm not quite as familiar with that.
Justice Wall, I will admit I am not particularly familiar with the KLAP resiliency program. That may be a question better for Mr. Gamble and his counsel, just because I am not an expert on that program apart from, frankly, its existence. And so I apologize.
No problem.
Just to touch a little bit on the aggravating and mitigating factors that are part of this summary submission agreement. I'm actually going to start with the mitigating factors because compelling to the disciplinary administrator is that neither the judge nor the lawyer sister, as I keep referring to her in this case, wanted Mr. Gamble to lose his law license over this misconduct. The position of those most impacted by the misconduct was a strong mitigator in this case. He lacked a selfish or dishonest motive. He has been participating in the resiliency group to deal with the sort of natural stressors that come with the practice of law. There are character letters in the record, and Mr. Gamble is an active and productive, respected member of the bar. He has demonstrated genuine remorse. He has accepted accountability by entering into this agreement, by being willing to do the probation plan. And he does have prior discipline, but it is remote in time, if not in character in all cases, which again was a mitigating factor.
Does that suggest that had the, I'll say victim of the misconduct wanted a full bore prosecution, if you will, wanted an indefinite suspension or disbarment, does that suggest that the disciplinary administrator's office would have sought a higher sanction in this case?
I don't believe that, Justice Stiegel, but I believe sort of in determining what is appropriate, or rather the appropriateness of something like probation, just knowing that those most impacted would essentially rather see the safeguards of probation than something like a suspension is telling. My understanding, I did not try this case. I was not the attorney who put together the summary submission agreement, is that both of those parties recognize the work Mr. Gamble does in the community with which he works. And so that was just an important part.
So is it fair to say that considered sort of in the abstract prior to considering aggravators and mitigators, that your position is this conduct would warrant a suspension without probation?
I would say that is, given that there was also a prior suspension, I don't think that's an inaccurate statement. I think oftentimes the starting point is what the underlying discipline should be, and then the appropriateness of probation once that underlying discipline, if it's suspension, the length of suspension, is the sort of layers of consideration. Thank you. So as I mentioned, there is prior discipline in this case. Some of it is similar in conduct with, again, sort of the not completely recognizing perhaps the line between zealous advocacy and overstepping zealous advocacy. And again, this probation plan is tailored to address those concerns and issues in this case. And so if this court does not have any other questions, I would simply ask that the summary submission agreement be approved and that the joint recommendation of a 6-month suspension stayed for 12 months probation be imposed in this case.
I have a couple, oh, go ahead. So I'm looking at a letter that that is actually from Mr. Gamble's other counsel, Ms. Belquist. And it makes reference, it's dated in August of 2020. And when did this incident occur? Just remind me.
The underlying conduct?
Uh-huh.
It started in, I believe, no, it started in early 2020. I believe,
Okay.
January is when he joined.
Okay, so it's, and it says, it is no secret that Mr. Gamble has a previous disciplinary history and then it asks that the same person who is investigating that case, investigate this case, right? That's
I
what-
don't have that letter in front of me, Justice Standridge, but I have no reason to disbelieve that's what it says.
So it kind of makes it sound like the previous complaint was not remote in time.
So that may be referencing other complaints, which,
Oh. Okay,
I don't have the
Okay.
letter in front of me, so, but I am talking about previously formally imposed discipline that would have, in fact, with the exception of his previous diversion, there was a formal complaint, a formal hearing, and the whole process.
okay. And so just as a general statement, nothing to do with this case, but as a general statement, you don't consider complaints that aren't brought to hearing.
Correct.
How does that work?
Justice Standridge, until and unless there is discipline imposed, which is, I believe, begins with an informal admonition, diversion, or then suspension, beyond just, if there's a complaint that is then when it reaches the review committee, does not go forward for formal discipline, then it is not part of, that's in fact confidential. And so it is not part of those considerations.
Okay, so if there is something pending, do you wait to go forward with us until that pending?
I am not the individual within our office who sort of manages all of that, but my understanding is if it is known that an individual has several pending matters, cases may be held and considered together, because if ultimately the determination is that it is to go to formal hearing, to try those together rather than to have, several, especially if it's similar allegations of misconduct. Does that make sense?
Yes, thank you.
I'd like to key off of Justice Stiegel's question as to, where we draw the line between zealous advocacy and improper conduct, because KRPC 8.4D is one of the more nebulous aspects of the disciplinary code. It's professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. And in wrestling with that question that Justice Stiegel raised, in my mind, in this case, would you agree that some of the complication there is that we have a lot of very serious and emotionally charged things going on in this case? They had originally lived in Utah. A statement had been allegedly made by the wife that she was going to take the kids to Mexico. There was a terrible incident in Mexico, family incident such that people were killed. She wanted to take the kids. He didn't want to take the kids. Then she picked up the kids from school and left and went to Kansas. And then the sister lived in Johnson County. The case was filed in Wyandotte County, and some of the pleadings indicated that wife lived in a confidential place. So we have legitimate issues of potential forum shopping in that I still don't understand the link with Wyandotte County. But also the home state, which place should have venue under the UCCJEA, and whether or not there had been some alienation. There were potential serious issues and emotionally charged issues against the wife also, right? And so doesn't that make it much more difficult within the context of a case like this to determine where the line is between advocacy? Because all those things would have to be proved and shown with evidence, and going too far, such as listing PII or ad hominem or personal attacks.
Here's Justice Lukert. I see that I'm out of time. May I answer Justice Wilson's question? Justice Wilson, I don't think anyone is arguing that the issues about is venue and jurisdiction proper under the UCCJA or the charged family concerns with what was going on in Mexico were inappropriate to raise in the context of this case. But there were ways to raise it without including PII, without including sort of the additional potentially controversial information about the family. It's important to note that at the protection from abuse hearing where both the husband and wife testified, and I apologize, I do not remember which exhibit number that is, but it is within the record, there were references and testimony about what had happened in Mexico. And I believe Mr. Gamble's motion even cites to when the husband discussed that. There was therefore not a necessary reason, a legal purpose for bringing up the social and religious views of the extended family, of attaching newspaper articles, one of which included a family incident from the 70s that is potentially controversial and not, from the record before us, linked to what had happened in November with the violent incident, which seemed to be a random act of violence. There were ways to bring up, the not knowing where the confidential address is, because in PFAs, addresses are confidential of the protected party, and whether it truly was Wyandotte County without rising to the level of the accusations, the personal accusations of forum shopping. And there's a level of essentially suggesting that the sister was meddling in the affairs of this family improperly. In emotionally charged cases, it is natural that parties will become very heightened and oftentimes add information that perhaps is only, unless you're living the case, does not seem to be relevant. But this is beyond that because it was very personal. It was potentially controversial. And again, the PII is also an important aspect of it, is that the necessity of including her home address. There really was none. He could have alleged the sister lives in Johnson County and they're living with her.
May I ask one more question, Chief? All of that was considered in your understanding that the agreement is that the respondent did go too far in doing some of those things, and also all contained with what was considered in suggesting the discipline that you jointly discussed.
Yes, so the stipulation is that those facts that I just laid out, and they are laid out in the summary submission agreement and supported by the exhibits in the record, is that that was a violation of KRPC 8.4D, which is also part of the stipulation. And all of those elements were considered in making this joint recommendation of probation and the plan that is really sort of centered on making sure that a neutral and detached person is reading pleadings in highly emotional cases like this one to assist Mr. Gamble in making strategic decisions about what to include and what not to include.
Thank you.
Questions? Thank you.
Thank you very much.
Good morning, Christopher McHugh for Mr. Gamble. I will try to be as brief as I can because Mr. Gamble does want to come up and address you as well and answer some of the questions that you've asked. First, though, I would like to state, because of some questions on prior discipline and prior cases, Mr. Gamble's prior case was 10 years ago. So it was very remote in time. It was a decade ago. I'm not familiar with the letter that was referenced either, so I'm not going to speculate, but there were several complaints and investigations that were related to this and involved other parties that we were seeking in discovery at one point. So I don't know if that letter is related to that or not, but I don't believe it was related to any discipline or investigation of Mr. Gamble, any additional investigation. I don't know how far to get into this, but I think it's important for the court to understand the situation that we were in before we got here from a legal position. First of all, Mr. Gamble was not sanctioned by the district court. His client was sanctioned by the district court. And that may seem like I'm splitting hairs, but there's an important effect that comes off of that. Mr. Gamble did not have the decision on whether to appeal that. It was not his case to appeal, and his client decided not to appeal that sanction. So he didn't have control over that. And in these proceedings, these ethical violation proceedings, that order, that judgment then becomes a legal presumption. Under rule, and I believe it's Rule 216, but I'm not sure about that, it becomes the law, the facts of the case. The judge's decision is presumed to be accurate and true and right unless it is rebutted. Our plan at the panel level was to rebut that with legal experts. Some attorneys that are barred in Kansas that do domestic work that would come in and say that what Mr. Gamble did was relevant. There was a legal purpose for it. We were not allowed to do that. So we weren't, it's already been brought out here, I think, in questioning, but listing the home address, there was a purpose.
What do you mean you weren't allowed to do that?
That evidence in a pretrial hearing was rejected.
By the panel?
Correct. So that, not to put too fine a point on it, that leads us here. And that's not to take away from anything that Mr. Gamble's about to tell you about acceptance of responsibility, because he does accept responsibility. He is accepting responsibility. And we are agreeing, pursuant to this agreement with the ODA, that he did overstep. I think that's a good way to put it.
Let me press into that a little bit. I'm sure you appreciate and recognize the internal contradiction between preparing a defense with legal experts to demonstrate the relevance of the material and the appropriateness of the material, and then filing a summary submission where you admit the opposite.
Let me try and nuance that a little bit and make those fit together.
Okay.
Because I do in my mind. They really do. Talking about this stuff being relevant, it can be relevant and still be overstepping in the way it was presented. And I think my opposing counsel talked a little bit about that.
Help me understand that.
Don't go in to a court trying to be persuasive and be overly aggressive in the way this case was handled. This was not persuasive to the court. In fact, it pissed the judge off. I'm sorry.
Yeah, so it might be, I mean, it could be negligent and it could be bad lawyering. That's what you're saying.
I think
But if it's relevant evidence, how can it ever be an ethical violation?
I think, given the position that we are in,
And I appreciate the position.
it
you're
was,
in. I
it was
understand.
very reasonable and still is very reasonable for us to say, we ethically stepped over the line. We were too aggressive and it interfered with the administration of justice. Regardless of our position.
You were
on-
too aggressive in asserting relevant evidence that was favorable to your client's client.
Correct.
Okay.
Correct. I think that's the position we're in. And legitimately, I think you're going to hear Mr. Gamble come up here and he's going to honestly say, I wish I would have done this differently. And I do think he's going to say, I think, that it did impact on the way the case was handled. And it did, you know, I am torn, sir. I am torn because one side of me as a litigator of 20 years wants to say, you don't want to make a litigator scared to make their case and scared to make someone upset or scared to take a certain position. But at the same time, I don't like the way Mr. Gamble presented this case as a litigator. And I think there is a fair argument that he overstepped.
I mean, ipso facto, he made a bad case because of the outcome, right?
He was not persuasive. He was, I don't want to characterize it because I don't want to put words in his mouth, but it made several people very angry, and we're here now, and we didn't have to be here. That's how I see
Let
it.
me see if I can help you out.
Please.
Ms. Duncan Butler said, you listed the sister's address in the pleadings. Now, knowing this is, someone who's very angry now knows exactly where the sister lives. And it could have been appropriately said by saying you have reason to believe that the respondent could say, mother was living in a county other than Wyandotte County. She had lived in Utah, and there is, and we have potential forum shopping here because there is no link, legal link between the county where she lives and the county where she filed. I mean, it's said longer, but you don't have that personal information.
Correct. That could have been done. It would have been a better way to do it. And it would have been much more sensitive to the party's perspective. I have trouble with that particular piece of that particularly being troublesome here. I have more trouble, frankly, with the tone and the presentation and the way some of these things were said and the confrontational nature that didn't have anything to do, was unnecessary in the
I mean,
presentation.
I presume that you're not saying that the address was irrelevant to the legal issues being presented.
I can't say that.
Ah.
Yeah, I can't say that, but I can say that being too aggressive in a case can affect the case. It's not persuasive, it's not helpful, and I can see where it rises to the level of an ethical violation.
What about the relevancy of the religion and the relevancy of the initial murder? I mean, like 10 years before the more recent one that led to the argument about going to the funerals.
Yeah, I don't remember. I go off of Judge Mahoney's order, sanctions order, and what he pulled out, and I don't think those were in there, or at least not quoted, or I don't remember those specifically. But yes, I think that's a good example, generally speaking, of going too far, being too aggressive, being too zealous. That's all I have. I do want to give Mr. Gamble a chance to speak here. I would close, though, by urging the court. We have worked very hard on this case. It has been hard to come together and come to a consensus and a resolution that everybody thinks is appropriate, including Mr. Gamble, including myself, including the Office of the ODA. So I want to emphasize and let you know about that work, that it took a long time to get here, but we all worked together to get here. The probation plan is going quite well, and there's no reason to believe it won't continue to go well. And considering the really outstanding mitigating factors here as well that I draw your attention to, I just urge you to accept the resolution that is being put forth by all parties.
Counsel, was there any effort among the parties to specifically identify those things that occurred that were over the line? Or is that something that was just a little more of a negotiated agreement, that there were some things that went too far and so that we could go on down the road?
It was very much the latter. For better or for worse, we did make that effort. There wasn't a common ground there, and we needed to get to a resolution that made sense to everyone. So we made that a little vague, I'm afraid.
So I entirely appreciate what you're describing, which is from you, your client's perspective, the Office of Disciplinary Administrator's perspective, wanting to find a way to move on down the road, I think, as Justice Wilson just said. The one thing that doesn't consider, and it's not your job to consider, but it's our job to consider, is the precedential effect of just sort of stamping, signing off on an agreement. And I'm not suggesting you or the Office of Disciplinary Administrator has any responsibility to consider that. But since you're in front of us, I would just ask you to respond to, is there a concern that there's a precedential effect of this agreement that might distort the law in this area?
I'm always concerned about that in these types of cases where you have, and in the mitigating factors in the joint submission, you can see that we've agreed that the motive here was not pure, but it wasn't improper, that we agree that Mr. Gamble was trying to represent his client in a way, he just went overboard. So I'm always, having litigated for 20 plus years, I take a lot of positions that make a lot of judges mad. I want to feel comfortable doing that as much as I can and feel like they're not going to call me out and endanger my license. At the same time, I would not present to this court or any court a resolution of a case that I didn't think had a factual basis and I didn't think you could get there solidly. So I am not presenting something to you that I want you to rubber stamp. I cannot identify specifically the straw that broke the camel's back here. But I think in concert, what you have before you is enough where you're not putting a rubber stamp on this. I think Mr. Gamble will come up here and say he went too far. He was too aggressive. And it stepped over the line of an ethical violation. And whether that was way over the line or just over the line, he's willing to admit that. And I think you should take it at face value.
Counsel for the ODA's office, and I want to thank attorneys for representing me through this very difficult process the last 4 years. Chose to agree to a stipulation to a violation in this case because I thought it was the best thing to do for not only myself, my family, my practice, my clients that I represent, for a resolution that would allow me to accept responsibility for some of the language that I used, overzealousness, you can call it, being a little too aggressive, not being as sensitive to intricacies and the emotional issues that were present in my representation of this particular client. I thought what I was doing was for a good cause and for the best of the client. I believed that my job as an attorney and a counselor is to educate the court, to research the issues, present the best case you can for a client. I did include information, public information from the internet. Some of the information was taken from a Utah case, a divorce case. I apologize. A Utah case that was open, and the documents I received from another attorney, I included those in my arguments in my memorandum. I have no ill will towards this woman. We've worked together many times in the past, but I did apologize to her. I apologized to the court recently as part of my probation plan, and I take responsibility for my efforts and my representation for my client. I think that in the family law courts, sometimes cases can get very heightened and a lot of emotions run high. Justice Wilson, when I was legal aid, you were appointed on the bench and I was with legal aid, and that's how I came to start practicing family law, and I practiced it for 20 odd years now, and it's never a dull moment. And but sometimes you have to take unpopular positions in your representation, And that's what I did. And appreciate the questions prior to my coming up here. And if the court has any other thing that, or issues that they want to know about, or
Can you help us out a little bit to, again, key on Justice Stiegel? Can you articulate to us how you would say you engaged in conduct that was prejudicial to the administration of justice by way of misconduct?
believed I caused my memorandum and my communications with the court caused highly intense emotions by having to state facts, make arguments, and it put a lot of pressure on people. And I didn't do it to be mean or to be spiteful. Did it because I thought those facts were relevant to advocating my client's position. And I was tasked with a difficult job in this particular case, this county. And I just tried to do the best I could. And I think I went a little too far and caused prejudice in the case that was prejudice to the administration of justice. And I accept that. I'm not perfect.
A practical question. Daniel Parker, what area of practice does Mr. Parker?
He does criminal defense for Spanish speakers.
Criminal defense? Is he familiar at all with family law?
No, and I think that's a good thing, because it gives objective perspective, I think. But Mr. Parker is currently unable, and I have
I'm sorry.
another supervisory that does this family law.
Oh, who is that?
Angela Trimble.
Angela Trimble. And is that in the, I guess, is there a new plan that was filed?
There was an affidavit.
Okay,
attesting to
Angela
the-
Trimble, and then, and is she in Wyco?
Yes, ma'am.
Okay, and is your primary practice in Wyco?
It's kind of spread out. Johnson, Wyandotte, Jackson.
Okay,
Can you tell me about the resiliency
Yes,
groups?
it's an online, they do it twice, 3, 4 times a month, depending on the person who's presenting it, their schedule. It's an opportunity for lawyers who have faced disciplinary issues or currently facing disciplinary issues, therapy amongst colleagues, going over life issues, practice issues. The moderator gives a lot of good practical tips, books to read, meditation, practical things that lawyers who routinely are engaged in high conflict, they can bounce ideas and just generally talk to other lawyers, encourage them. I've enjoyed it. I mean, there's people in there that I can really relate to and are going through a lot of issues, and I do enjoy those sessions. Wish everybody health and goodwill, and happy early Mother's Day weekend for the mothers.
Unless this court has any particular questions, I would waive my rebuttal time.
I just have one question. So when we get down to it, well, would you agree with Mr. Gamble that the prejudice to the administration of justice beyond, putting in PII, that it, he caused high emotion and put a lot of pressure on people? What else would there be?
Justice Standridge, I think it increased the adversarial tenor of the proceeding in a manner that was prejudicial to the administrative justice, because it became not about those issues that Mr. Gamble was trying to raise. It became more personal. more intense and emotional than necessary, and ultimately cost more time, resources, and expense, including for Mr. Gamble's own client. And I apologize for misspeaking that he was sanctioned. That was my mistake, and I apologize. For his own client, in sort of separating the personal and the irrelevant information from the actual issues that were being raised. And so that is the prejudice as well.
Is it the view of the ODA that increasing the adversarial tenor is a violation of the rules of professional conduct as opposed to sanctionable conduct, that a judge is just controlling the courtroom and you're causing high emotions, you're causing, adversity, you're causing more money to be spent, your motion practice is higher, because as a litigator yourself, with a history of litigation, many, many years, this is not unique. And if we, I'm asking you, if we make this our standard, how many cases will we have?
Well, Justice Sandridge, I would back up a step to your initial question, which is it sanctionable or an ethical violation? It can be both. There are sanctionable things that happen in cases that are also ethical violations and come before the disciplinary administrator, and it, are handled through this process. Every case is different and sits upon its own facts. And I am not pulling the citation out of my head, but there's been a recognition by this court of that fact. And so what is, is this uncommon? No. Is this beyond what is, the only way I can think of it is like stair steps of, yes, it is not uncommon in family law for an attorney or a party to occasionally step beyond what is zealous advocacy. However, it is leaping beyond, going up 2 or 3 stair steps.
This is leaping?
It is, I think, more severe than an ordinary case, given the concerns with the PII, given the increase of adversarial conduct and the personal attack against.
How familiar are you with family law?
I did practice some family law when I was in private practice. But there is a difference, I think, between intense information and argument about the party's behavior and then looping in a third party, in this case, the sister attorney, and not projecting, that's not the word, but then making accusations against that person and sort of drawing them in.
But why shouldn't the judge just have control over that? Why are we turning that into an ethical violation? I mean, because, as Justice Stiegel said, this is opening the floodgates if all of a sudden these are all ethical violations for overzealous advocacy that brings in irrelevant information. Because it just seems like, if in a criminal case, in any case, it's like, you bring that in, objection, Your Honor, that's irrelevant, irrelevant evidence is introduced all the time or attempted to be introduced all the time. If that happens in a criminal trial and a lawyer elicits irrelevant information about a victim, and before they can finish, it comes into evidence and the objection is, sustained. So it comes out of the transcript. Is that now an ethical violation?
Chief Justice Lickert, I see I'm out of rebuttal time, but may I answer Justice Standridge's question? Again, Justice Standridge, the issue here is not simply that the information was irrelevant. It was that it was objectionable. It was beyond just including irrelevant information, but it got personal. It brought in potentially controversial family information that was.
I'm not arguing it wasn't wrong. My issue is, that it's attorney misconduct that can be controlled by a judge versus, rising to the level of professional misconduct where you can punch somebody's ticket.
My answer to that would be that just because a judge is able to sanction and perhaps control a situation does not take away from the attorney's duty to comport with the rules of professional conduct, does not undermine our duty as our office to ensure that those rules are being followed, to investigate and then go forth with cases where there were violations. It's reminiscent to me, to pull from my criminal law background, of State versus Sherman and prosecutorial error versus misconduct. There are situations that don't rise to the level of misconduct, but I would imagine that if a prosecutor was committing the kind of misconduct that brings them before our office, this court would still consider whether it causes reversible error in the criminal case and vice versa. It can be, there are parallel tracks, and there are probably, I don't have, the full historical knowledge of every case that's been before our office, but I'm certain that there are times attorneys were sanctioned and they don't end up standing here because the finding was that the ultimate determination by the review committee or whomever was that while their behavior was sanctionable, it was not to the level of misconduct, but it can also be sanctionable and be so overzealous, so prejudicial, so inappropriate that it must also fall under the rules of professional conduct.
So it's the ODA's position today that it was so overzealous, so prejudicial, and so, I forgot the last word, that's what brought us here today.
It is the joint position of the parties and their stipulations that Mr. Gamble's conduct in this case was a violation of KRPC 8.4D.
Thank you, counsel.
And I have two really, I know we're way over time, but I do have two, I hope, really quick questions. Would you agree that the summary submission does not include an admission that the evidence introduced was irrelevant?
I was just reviewing the summary submission agreement and I
have it,
my binder very quickly.
sure, I have it in front of me.
Oh.
And again, as I read it, one of the admissions is that the district court found some of the evidence to be irrelevant, but there is no admission that the evidence was irrelevant. Would you agree with that?
Justice Siegel, I would agree with that. I just double checked.
So then my second question is, would you agree with me that it is not an ethical violation to introduce relevant evidence just because it contains PPI? There's no rule against bringing forth relevant evidence that contains PPI. That would hamstring half the trials that happen.
I am not able to fully recall the rule on how PPI is to be presented in pleadings and such. My recollection is that it needs to be redacted, but I may be incorrect on that. And if I am, I apologize, but it is,
There are a few specific rules that most, and again, maybe both of us are flying by the seats of our pants here, but that relate directly to things like names of minors. But my recollection is those rules are quite narrow. I mean, in a collections case, for example, you got to include count numbers.
right.
That's PPI.
Yeah, Justice Siegel, I would say, if you're asking if there is a per se, no PPI can ever be mentioned, then I would agree with you. However, in a case like this, that is involving protection from abuse, a protection from abuse case, allegations of domestic violence, and the fact that the person whose PPI was being placed in this is not just, she's not a party to the case, she's a third party, that sort of changes the analysis from the person.
Is there any rule that says that?
Again, I would have to look, like you, at the exact rules regarding PPI that I don't have memorized, and I apologize.
Well, if there is no rule that says that, would you agree that there's nothing at all wrong introducing such relevant evidence that's not barred by some rule?
I think there are ways to do it that are not also have the auspices of a personal attack.
There's not been much mention, I guess. I'm wondering what part the Utah court order comes into play. As I understand it, and maybe I'm going back and looking to see, maybe I drew conclusions from reading that and I see some ambiguity, so I may have drawn improper conclusions. But I'm looking at the formal complaint as it walks through, and I think what it was referring to in paragraph 7 of the formal complaint is the Utah order about the emergency hearing, in which the judge made some findings that not Mr. Gamble, but another attorney had filed documents that misled the court. And then we have essentially Mr. Gamble filing those same, or many, and some of the same documents later in the Kansas court. That come into play in what we're talking about here, or am
So-
I connecting dots that don't connect?
My recollection, Justice Lukert, and I don't have picture perfect memory of the Utah order, was that the misleading information was that the Utah documents filed asserted that the husband there was nothing pending in Kansas when the husband did have information about things pending in Kansas. That's my recollection as I stand before you. It could be a misrecollection, and if it is, I apologize. But it is accurate that Mr. Gamble, some of the information that was raised in the Utah divorce about the extended family is the information that Mr. Gamble subsequently also included in his motions here. But, you know, the Utah case is, that part is its own thing.
Thank you to all of you for your arguments. Court will take this matter under advisement. Check to see where we are in 127196. I still don't see Mr. Maughan, but have we had any further communications or? Yes, please.
I just spoke with Bryn Rose from the Kansas Lawyer Assistance Program, who has had communication with Mr. Maughan this morning, and he will not be present, and it is not at this time due to car trouble.
Well, I think we will go ahead then and call 127196. Matter of Carl Maughan.
I should have done my introduction, but I was a little off
Yes,
there.
yes,
Madam
go ahead.
Chief Justice, may it please the court. Alice Walker, Deputy Disciplinary Administrator on behalf of the Office of the Disciplinary Administrator. I am not requesting any time for rebuttal.
But you do think it's appropriate for us to move forward? And I don't know that we should put any extra, any communications or anything on the record here with, I'm not, but you are requesting that we move forward.
Yes, Chief Justice, in the information that I have received this morning, it is my belief that we can move forward and that Mr. Maughan is making a decision to not be present for the oral argument this morning, and that extending this to the end of the docket would not change the position that we're in at this time. And so with that, I'll say I'm in a different position than I thought I would be starting this argument. This is an original proceeding in attorney discipline involving the respondent, Carl F.A. Maughan, who has been licensed to practice law in the state of Kansas since 1997. This disciplinary action arose out of the Kansas Court of Appeals unpublished decision in State v. Blevins, in which the court found that the respondent had a conflict of interest in his representation and that he did not obtain proper written waivers as required under KRPC 1.7 and 1.8. Because of that, the Court of Appeals reversed those convictions, remanded the case to the district court for new trial with new counsel. I had anticipated already letting the court know that at this time, the disciplinary administrator was changing its recommendation from the hearing. At the time of the hearing, the disciplinary administrator joined in Mr. Maughan's recommendation for probation, believing that the plan that he had created was workable, substantial, and detailed, would adequately protect the public, and would ensure his compliance with the rules of professional conduct. Unfortunately, since the hearing, which was December 7th of 2023, the respondent has not been in compliance with Rule 227. And so my recommendation today had already altered to where I was asking this court to impose a 6-month suspension with the requirement of a reinstatement hearing. With Mr. Maughan's position and his absence from this court, what I understand to be whether he had car trouble previously or not, I have not directly communicated with him. I know that's what he's indicated to the court, but I know that at this point he has made a conscious decision to not be present in front of the court. My recommendation has changed to a year suspension with that reinstatement hearing.
Is there evidence in the record of concerning noncompliance with probation plan? Or I'm just curious how we consider that or evaluate that if there's not.
I would say it's what is absent from the record that shows the noncompliance. Pursuant to Rule 227, I believe it's F, a respondent that is seeking to ask for probation from this court is required to file an affidavit at least 14 days prior to the oral argument showing his compliance or their compliance with that probation plan. And in addition, I think it's subsection B of that, or maybe it's the second subsection, indicates that he is to serve any reports or information upon the disciplinary administrator's office regarding compliance. What I can indicate to this court is that in his probation plan, it's paragraph 21, and it can be found at volume 1, page 89 of the record. He was required to submit monthly reports to the disciplinary administrator's office by email. And essentially, he would not engage really in private practice, but would only do this business transactional work with his one client where he was in-house counsel. He had a second client he did some work for, but he would do that and he would work with his practice supervisor, and he would monthly email the disciplinary administrator's office and essentially say, here's what we've been doing, no change, or here's the changes, whatever happens to be. Since December, the disciplinary administrator's office has received no monthly reports from Mr. Maughan. I can indicate that him and I have had 2 conversations about probation. One occurred in March, in which I had learned that his practice supervisor, Mr. Bell, had filed to run for judicial district or for judge. And I indicated to Mr. Maughan that I can't advise him. I'm not his attorney. I don't know specifically how that would work, but it would be my assumption that a judge could not actively supervise an individual's law practice, and that I encouraged him to look for an alternative so that when we came to the court, we could indicate if a contingency plan needed to occur, that a contingency plan was in place, because that was a big part of his probation plan. The second conversation that Mr. Maughan and I had about his probation plan would have been 2 weeks ago, in which I reached out to Mr. Maughan and indicated that I had not been receiving reports from him and that his affidavit was due that Friday, 14 days prior to today's hearing. Mr. Maughan did indicate at that time he thought he had been giving regular communication to our office. I double checked. I have also checked with my office, and I let Mr. Maughan know that I did not have that communication, but if I was missing it, to please let me know. And he never responded to that email. Mr. Maughan and I again spoke earlier this week, in which Mr. Maughan and his practice supervisor, who had been here, I would say, to support him, but also had his own court hearing at 11:30 and needed to leave for that. It was reported to me at that time that Mr. Maughan has parted ways from his current employer. And I don't know all of the specifics of that, but that at the end of this month, he will no longer be employed as in-house counsel. Based on the testimony at the hearing, that part of his remedial measures were moving away from that overwhelming criminal caseload and into this more transactional work, making sure that he had just this one client and wasn't going to be overwhelmed with the other personal stressors he testified to at the hearing. His statement of leaving this employer was concerning to me. So I asked Mr. Maughan what he was going to do in lieu of that, and if he was going to be altering his probation plan before appearing before this court. Mr. Maughan expressed some statement that he could work with this other client and maybe pick up additional work, but it would not be full-time, and that he may be looking into the area of estate law and that practice, but that he was not familiar with it and would need to do some continuing legal education. All of that information, coupled with the original misconduct, the aggravating factor, specifically the harm that had occurred in this case, and the standards that I believe the disciplinary administrator's office believe are appropriate in this case, which is 4.12, 4.32, and 7.2, has altered my recommendation to indicate that at this time, I don't believe that Mr. Maughan is able to comply with a probation plan. But at this time, this plan isn't even workable or substantial due to those changes, and my recommendation is for a suspension. Due to his not appearing before this court today is why, instead of a 6-month suspension, I am now asking for a year suspension. I do think a reinstatement hearing would be appropriate in this case. The reasoning for that are all those same factors. The mitigation at the hearing, the respondent's actions of moving away from that private practice work, which he said was overwhelming. He had a huge caseload, and that contributed to the misconduct. And those steps that he was taking took this from where I saw the suspension as the standard recommendation of discipline based on those American Bar Association standards. But I believed that the work that he had done and that he had put in place was a workable, substantial probation plan. And again, because at this time, it does not appear he can work on that he may be looking into a different area of law that could be overwhelming without that plan in place. I think a reinstatement hearing would be important to know that if the court accepts a suspension and does impose that, when he comes back into the practice of law, he has that plan in place that's workable, substantial, and protects the public. Without Mr. Maughan here, I don't have much other argument unless the court has questions for me.
You're probably more familiar. You are more familiar with the rules than I am. You probably know them backwards and forwards. So would it be appropriate for you to file any post-argument pleading or affidavit regarding what you're calling what's absent from the record, as Justice Wall kind of pointed out, that that the probation, that the rules required him, or I guess the probation plan required him to submit monthly reports, and there have been no monthly reports since December, and that, because the court can't say the monthly reports, we don't, we're caught by all our stuff is from November. We don't even have anything from December. And so we don't have that. And, I guess we could say that we don't have the 2-week that would have been filed with us. So that absence, we can say that he hasn't filed his affidavit, right? Because that comes to us too.
Correct, Justice Standard. His duty under Rule 227, and I think the purpose of Rule 227 and the burden being on the respondent is them saying to our office, to the hearing panel, and then to this court,
Yeah.
I have put this plan in place. I am doing it. I am working it. And
Okay.
here is my affidavit saying that I have done all of this.
Okay, so
And-
that's probably good enough that hasn't been filed.
And so under F, and it's 1, says he must comply. 2 says at least 14 days before oral
Okay.
argument, he must complete the following, and it's A, file that,
Okay.
and serve our office. And I think when in a typical case where a respondent is seeking probation, when they file that affidavit, they're providing all the information, and they're also certifying, I've given the disciplinary administrator all the information I'm supposed to which then I think allows us to have that as part of the record, even though it's a pleading right before the oral argument, to be able to discuss those things with the court. This is a unique situation where the respondent has failed to comply with that. And so it's what's absent from the record
Okay, got
that
it.
shows the failure to comply.
I'm trying to remember our case law, and with some apology, I can't get into Westlaw from here because I wiped my password away.
Oh,
I
no.
didn't know it until I got here. So so I have to, but here's my question. I know that we have had cases and where the respondent fails to appear. And do you recall how we've handled that in our opinions? I know it's a violation, but an extra violation. My memory is that we just note it and enhance the discipline but I don't honestly, I can't find, I can't look.
And I will be honest, I did not look that up this morning because I did not anticipate Mr. Maughan not appearing today at this hearing. And I think it is viewed, I don't know that it's considered an additional violation, like a duty to cooperate. But I do have some recollection of discipline being
No, you're required to
enhanced.
be here, and it is a violation. I just
Yes.
can't quite remember procedurally how to handle it, but hopefully there's somebody working for me that will help me get that later today. As a Westlaw password.
Thank you.
Now call 127-337. Matter of Darren Fulcher, respondent.
Madam Chief Justice, and may it please the court, Kate Duncan Butler appears on behalf of the Office of the Disciplinary Administrator. I would respectfully request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. This is an original proceeding in attorney discipline involving the respondent Darren Fulcher, who has been licensed to practice law in the state of Kansas since 1999. This matter comes before the court after an evidentiary hearing held on January 18th, 2024, that included a joint stipulation by the parties. In that stipulation, the parties agreed to the facts underlying this case, as well as violations of KRPC 1.8 subsection E, providing financial assistance to a client, 1.15 subsection A, safeguarding client property, and 1.15 subsection B, promptly delivering funds to clients and third parties. In the final hearing report issued on February 7th of 2024, the hearing panel made findings of facts and conclusions of law, including that Mr. Fulcher violated the rules I just outlined. No exceptions were filed by the parties, meaning that the issue today before the court is the appropriate discipline. Today, the disciplinary administrator is recommending differently than they did at the hearing panel. It is our recommendation that Mr. Fulcher be suspended from the practice of law for a period of 2 years, but that suspension be stayed for a period of 2 years probation. To get to why the recommendation has changed, I will summarize the facts and then talk about what has happened subsequent to the hearing. To highly summarize the facts, Mr. Fulcher's practice is primarily personal injury and some criminal defense. Many of the personal injury cases are on a contingency basis in the Kansas City area. In June of 2021, the Missouri Office for the Chief Disciplinary Counsel, which I will refer to as OCDC going forward, reported that an information, which is like a formal complaint in Kansas, had been filed against Mr. Fulcher regarding his trust accounting practices. OCDC had audited and investigated Mr. Fulcher's trust accounting from December 2017 to September 2020, and found that he had insufficient and inadequate trust accounting practices that led to clients and third parties not being promptly and completely paid. The pattern that essentially emerged, to summarize the many instances, is that Mr. Fulcher would receive settlement funds, deposit them in his trust account, prepare a settlement statement for the client indicating what money went where, what does the client get, what does Mr. Fulcher get, what's expenses, what goes to third parties. But then those payments didn't always get made promptly or fully, including sometimes Mr. Fulcher not paying himself immediately. The end result was that there were around 20 clients who were impacted by this. Notably, during the audit process with OCDC, as the investigator found places where payments hadn't been made, Mr. Fulcher immediately made each of those clients whole. So at this time, that all has been corrected, in fact, was corrected long before the hearing in this case.
When you say clients, does that also include third-party lien holders?
Yes, I apologize just as well. Anyone who was owed money it had been resolved. The investigation also discovered that Mr. Fulcher had made large round number withdrawals from the trust account, not based on the exact attorney fees earned and owing, and that there were times where his account balance in the trust account was less than what was outstanding to be paid out. Mr. Fulcher has acknowledged he was not reconciling the accounts and essentially trying to keep all the numbers in his head. After a process with the OCDC and a formal hearing in Missouri, the ultimate result was that the Missouri Supreme Court suspended Mr. Fulcher's law license on November 22nd, 2022, and said he would be eligible for reinstatement after a period of 2 years. So in November of this year, he will be eligible for reinstatement. The Kansas Office of the Disciplinary Administrator filed a formal complaint in reciprocal discipline involving the Missouri trust account in November of 2023. Mr. Fulcher answered on December 12th of 2023. And as I previously mentioned, before the formal hearing, the parties entered a joint stipulation, leaving the hearing panel to consider the appropriate standards, aggravating circumstances, mitigating circumstances, and discipline. At the time of the hearing, the disciplinary administrator recommended a 2-year suspension from the practice of law retroactive to when the Missouri suspension started. Mr. Fulcher had, amongst the outcome he requested, asked for probation, but it was the disciplinary administrator's position at that time that his proposed probation plan did not comport with Rule 227 because it was not substantial, detailed, workable, did not adequately protect the public or have sufficient safeguards to address the misconduct. The hearing panel ultimately approved of the probation plan and recommended a 1-year suspension, stayed for 2 years of probation. But the hearing panel did recommend some additions to the to the probation plan to make it more robust. Subsequent to the hearing and before this case was docketed before the Supreme Court, Mr. Fulcher and the disciplinary administrator's office came together to revise and amend the probation plan to address the concerns that the disciplinary administrator had and to incorporate the additions suggested by the hearing panel, especially when it came to trust account specific and audit specific provisions. It is now the position of the disciplinary administrator that this amended plan does comport with Rule 227, does protect the public, include the adequate safeguards, meet all of those requirements. Mr. Fulcher put that plan into practice on March 6th of this year, and in the joint statement of no exceptions filed before this court on March 21st, we included the amended probation plan with that.
And effective, so the 2 years probation would be effective beginning when? Filing of the order or going back to March?
It is this court's determination of how they want to do it. I believe our request would be that all the time periods the probation would begin at the time of this order. That's usually standard.
At the time of the filing of the order.
Yes, of your
That's
order,
your
yes.
position. Okay, thank
Yes.
you.
So that is now the disciplinary administrator's position at this time is that Mr. Fulcher be placed on probation to work through the trust accounting sort of practices and procedures and improvements that are spoken to in the probation plan, as well as to attend the legal education included in all of that. To briefly touch on the aggravating and mitigating the standard found by the hearing panel and the aggravating and mitigating factors. The hearing panel discussed 2 ABA standards. Standard 4.12 states that suspension is appropriate when a lawyer knows or should know that he is dealing in improperly with client property and causes injury or potential injury. And standard 1.13, also referenced by the hearing panel, states that reprimand is appropriate when a lawyer is negligent in dealing with client property and causes injury or potential injury. But as I will note in a moment, Mr. Fulcher had twice been disciplined in Missouri by OCDC for essentially failures to comply with trust accounting practices. Also, we expect attorneys know their duties under the rules of professional responsibility. And so his deficient trust accounting practices is that he knew or should have known that he was not dealing properly. Apart from the prior discipline, the other aggravating factor in this case was that Mr. Fulcher has substantial experience in the practice of law and has been practicing since 1999. But the mitigating factors found and discussed by the panel are he had an absence of dishonest or selfish motive. The evidence was not that he was purposely taking money or attempting to convert client funds. It was simply deficient accounting practices. He has shown genuine remorse. He understands he violated the rules and the negative impact that has had on clients and third parties. He has had other penalties imposed in the form of his attorney discipline in Missouri. And he has previous good character. He is an active and productive member of the bar. I believe there are several character letters in the record. He is a trusted member of the community. There was discussion at the hearing about his involvement in the greater community in Kansas City. So unless this court has any questions, it would be our recommendation and request today that Mr. Fulcher be suspended from the practice of law for that 2-year period, but then have that stayed so he can be on probation for 2 years.
Is that retroactive or starting when the opinion is published?
For which part, the
The
probation? or-
suspension.
Our request would be that it start when the opinion is
Okay.
filed and published as well.
And,
So the
and,
oh,
no, just, he's still suspended in Missouri until,
He will be, my understanding is he is eligible for reinstatement in November of 2024. But like Kansas, the reinstatement process can take a little while.
thank you.
that was really, I was gonna say, so the practical effect of this is that for the next couple years, he'll be able to practice in Kansas, but he'll still be prohibited from practicing in Missouri.
I don't know Missouri's process very well. It may be less than a couple of years, but yes, if the practical effect is if this court follows the request and imposes the discipline we have recommended, he is still able to practice in Kansas while he is not in Missouri.
Do you know if there's any practical difference between the Missouri order that was indefinite, but stating he cannot apply for reinstatement versus, for 2 years versus a 2-year sanction and a 7 hearing?
Justice Wilson, I'm not an expert in Missouri's processes. What I recall being told is that that's how Missouri writes its orders, but I could be misspeaking. I don't know that.
So maybe no practical difference.
Yes. Thank you.
And Madam Chief Justice, may it please the court. My name is Todd Mulder, as indicated earlier, represent Mr. Fulcher, and maybe to address a little bit of some of those questions. Mr. Fulcher is eligible for reinstatement in November or December of this year. Apply for reinstatement. The Supreme Court will take that application, the information we provide. So
Not eligible to reapply until completion of the suspension.
not eligible to to reapply until the 2 years go.
All right, so we're looking at least November 24 in Missouri, but here the recommendation is upon filing of this suspension we would impose would be suspended.
Correct, and then he'd be put on probation in Kansas. And
Correct.
continue
Okay,
to
yeah.
be able to practice law in Kansas. Now, when exactly Missouri will reinstate him is varies a lot, from my understanding. Jim Moore in my office does a lot of that in Missouri, and even he says, who knows?
Yeah. Does the reinstatement application go to a panel to make a report, or does it go straight to the court?
Goes to the Missouri Supreme Court. I do not think it goes to a panel for like a rehearing on.
But let me ask you this, and maybe this is something that Mr. Fulcher would need to answer, but before all this happened, what percentage of Mr. Fulcher's caseload was in Kansas?
Before all this happened, he had mainly a criminal practice in Kansas, not a lot of civil. Civil in Kansas, he continues to maintain a criminal practice in Kansas, as he always. But his civil has increased. I don't know, Mr. Fulcher.
Okay.
In a minute.
Yeah.
I don't know his exact caseload, but I think he'll be able to probably better than I can. We don't have any disagreements with what was said by counsel. I might just like to talk about the fact that this audit in Missouri did start in heat of COVID, March actually, when everything was falling apart, 2020. And then what the OCDC in Missouri did was they subpoenaed, they had one complaint by one of his clients. I think she didn't want to pay the lien holder, wanted all the lien money made to her. Mr. Fulcher said, no, I can't do that. So then she filed a complaint with the Missouri OCDC. Ironically, her claim is not even part of what happened in Missouri. But as a result of that, they subpoenaed all of his bank records back to December 2017 through September of 2020. Did a audit, found several instances of issues with his accounting, with his trust account. And frankly, to be honest, and he has said this and will say it again, he frankly wasn't reconciling the account, wasn't really doing any accounting of his trust account, and he knows that was wrong and improper, and frankly what led to all these issues. Because just a little sampling of what some of those issues were, he would meet with his clients, he would have them sign the settlement sheet, and on there would be issues about lien holders, third-party holders, folks that were owed money. And on one in particular, held out the lien money. And as it turns out, that person's health insurer ended up paying that money, but he never got the check to the client, even though the health insurance company had actually paid the lien. And it's because he's not reconciling his account. He's not going through and following up and making sure that those things are being done in a timely fashion. So there's several of those types of lien issues where a lien gets negotiated down to a lesser amount and the difference isn't paid to the client. There's one case where his client was owed $3,400 roughly. They got paid $3,000. He didn't keep good records at the time, and he wasn't sure if that $400 was paid in cash or he also represented him on a criminal case. Wasn't sure if that was paid on some tickets. Called the client. He didn't know either, so he ended up just paying that $400 because the OCDC in Missouri said, well, where's the money? You got to pay that money. And he did. He did advance money to a client on a settlement that hadn't quite been done at $500 out of his own account, which is one of the violations we stipulated to. I think she was living in her car and had a financial crisis. Doesn't excuse it, but that was why he did it.
I'm having a hard time pulling up my documentation for some reason on the newest kind of beefed up probation plan. And maybe you're going to get to it, so I apologize if I jumping ahead of what is in place to correct the reconciliation issues in terms of maybe education and maybe ongoing audit or I'll let you just touch on that, but that's.
No, thank you.
PDF documents are freezing on me right now.
No, that's okay. And I think it is in there, but our original probation plan, which the panel found sufficient, and then we of course negotiated a more robust one, didn't have allowed for audits at the behest of the Office of Disciplinary Counsel, but now it's required. And in fact, so it's additional auditing. Mr. Fulcher has a accounting firm hired, Brain, I think, accounting firm is reconciling every month, but I think it's primarily additional auditing at the expense of Mr. Fulcher. And I believe just within the last 2 or 3 weeks, an audit did occur, and I think a report was sent to the Disciplinary Counsel's office, and she'll correct me if I'm wrong, but came back fine as far as everything was reconciled, the auditing, and that person went through and took those settlement sheets and went through the checks written and made sure the liens were going out and being paid and everything came back fine. I do believe that person, I do have some notes on it here a little bit down the road, but made some additional recommendations. One was to keep even a third ledger. So he's got his ledger for his trust account, his ledger for his just operating account. And he may be able to explain it better because I think he spoke to the auditor, but a third ledger that kind of keeps some kind of running tally that I'm not quite sure I understand. He also recommended monthly reconciliations, which are a little confusion, which is being done. I think he saw the quarterly one and thought it was just quarterly being done, but monthly is being done. So it's just a more robust, I think, overseen on a more frequent basis than what our plan provided for.
The last one I see that was filed was January 4 of 2024. Is that the last one?
The last one, I'm sorry.
Probation plan, terms and conditions of probation.
Filed with the Board of Discipline, so.
Right, that was our plan. And then
Okay.
in March 21st of 2024, the notice pursuant to Kansas Supreme Court Rule 2028 of no exceptions was filed. And attached to that was the amended probation plan, terms and conditions of probation. So that's where you find that. And it may be, you're not seeing it maybe because it's attached to the notice, but it was filed March 21st, 2024. So there's there was another occasion where deposits were made into his trust account and he was asked by the auditor, well, what was that for? And he wasn't sure. He thought it was co-counsel, but it's all evidence of very poor record keeping, and almost, almost not any record keeping to some degree on that regard.
Counsel, I want to make sure I wrote down accurately. I understood you to say that the respondent now has an accounting firm that trust account on a period.
Yes, and does it reconciles his trust account on a monthly basis. Yes, that is correct.
I got confused about that between that and what the disciplinary.
Right.
And
Yeah.
then does he have a supervising attorney as well?
Yes.
Okay.
And his name is Rich McLeod.
Oh,
He's
okay.
Attorney there. I mean, your reaction tells me you know who Rich is.
I know Rich, yeah.
Rich is, a longtime litigator. I think enjoys a very good reputation in Kansas City, does a lot of mediations and filed on a monthly basis. And Mr. McLeod is going to report to the disciplinary office about his contacts with Mr. Fulcher on a monthly basis. So I think Mr. McLeod frankly had a little confusion. He wasn't sure if he had to file those reports until this court gave its order. I think in reality, if you read the plan, he probably should have. I'm not sure he has filed any reports yet with the Office of Discipline, but fact has inquired about that. So, but throughout the Missouri and the Kansas proceedings, Mr. Fulcher has admitted and agreed that he did a terrible job of keeping records and managing his trust account, didn't appropriately reconcile his trust account, and those all resulted in multiple violations of providing financial assistance, mixing his funds, because he there's been no allegation of dishonesty or that he was trying to line his own pockets, those kinds of things. There's not an allegation of that in this case. So when they talk about mixed funds or not protecting a client's money, what that's getting into, as I understand it, is, when you leave your funds you've earned in there and say there's a lien against you as an attorney, then that opens that up to some kind of seizure by a lien holder against you. But there were a number of mitigating factors. We've touched on those: cooperation, evidence of a lot of letters from the community about Mr. Fulcher's and his involvement in the community, and his volunteer work, and would ask that and I'm going to sit down here, I've got about 4 or 5 minutes left, but we would ask that this court find that the new amended probation plan is robust. I mean, I think the goal in these kinds of things is correct the problem. What was the problem is that Mr. Track of his account like he should have. Hired the accountant in fall of 2020 that now reconciles his account. He's been audited since that time. No problems have been found. There's been no new issues. So that's been 3.5 years of that kind of supervision already. with Mr. Fulcher. And so if your goal is to discipline, make sure those issues are corrected, I think that this plan is robust, it is work. There's evidence now that it is working. So we would request that you, for that, recommendation that has been, discussed, that Mr. Fulcher be put on probation and that plan proposed by the parties be put in
Let me
place.
clarify, you agree with the 2-year suspension at the filing of this and the 2-year probate, and stayed with the 2-year probation plan? You're
Yes.
Okay,
Yes.
thank you.
I see I have about 3 minutes left, so I want to give Mr. an opportunity to address the court. But if you have any questions before I go, be happy to address those. Thank you, Mr. Fulcher.
Please, the court. I'm embarrassed that I put myself in this situation. I have to be here. I know that at one point, practicing primarily in criminal law, mostly federal criminal practice, I was on the CJA panel. I know Judge Finner asked me to join the CJA panel, bring federal cases over to me, and that's primarily what I was doing. Did have client I represented Ford Motor Company. But when I got client funds then, that time, third-party payout, I wasn't paying clients out. And so it was just, I moved over when I had earned fees. I wasn't even monthly reconciliations. And then at some point, I went on my own and I started practicing in 2012. A practitioner, my personal injury practice just, and it's no excuse. Single dad. I had gone through divorce. I was raising these two girls, and it was just working. Stopped. And so never stopped. And I thought, I have all this in my head. I got it taken care of. There were times when I double paid clients, and but I never wanted to hurt anybody. That was, that's just, and it broke me up. And came that I began to audit. I just was broke. Never wanted to hurt anybody. From March 13th, 2020, audited on a regular basis by Missouri. I hired 2020 hired accounting firm, take over doing the monthly reconciliations, and report that they sent to Kansas Bar recently. He did the monthly reconciliation. He also does a quarterly reconciliation. Well, one recommendation that they gave to me is to make sure I send over my client letters to them as well, so we can have some backup. My account is balanced. So I just don't want mercy on the court, and I apologize. Family, the young men that I mentor. Church family, I just.
May it please the court, and briefly, just because I know some folks were having trouble pulling up the amended probation plan. To clarify, that was filed with this court, not with the Board of Discipline, because it was part of the statement of joint exceptions. So it's not in the record that came from below, for lack of a better word. The major differences there is, in addition, Mr. Fulcher already had the accounting firm involved during the hearing. There was testimony from the accountant. That accounting firm is and was doing a sort of ordinary reconciliation of just what goes in, what comes out. And so the amended probation plan includes making sure that Mr. Fulcher's practice supervisor gets access to all of these records, including the settlement statements and client-by-client breakdowns, to do sort of an additional layer of reconciliation and recognition of what money in the trust account belongs to what client at what time, as well as the audit by our office. Our auditor went and audited Mr. Fulcher's account, and as was discussed, found that overall it was fine. A few recommendations for improved practices, but no red flags, nothing that jumped out as a problem. And then I do think the amended probation plan had a few, added a little bit more education and a requirement that he read the trust accounting handbook put out by our office. But those are sort of the added layers to what was in the original probation plan. So other than that, I don't have any other material for this court unless there are any questions.
Much a question, but perhaps a matter of file completeness that I may want to address while you're both here. I had made a note that we do have the affidavit of compliance with the probation plan, and it did refer to the amended plan. And that was filed with this court on April 26th. So I was going to ask, we've got the affidavit refers to amended plan, but I was unable to find the amended plan. And I think that, and I'm not finding it, my colleagues are in the same situation, that in the materials before us, that we have the notice of stipulation. And that, as you all know, or may know, we are the last to get a return of an electronic case management system. So this is maybe just one of those things that it's because of that problem, and it is downstairs or even in one of our offices, and we just haven't all been made aware of it. But there's a chance that we are missing that document. So you both do agree that that was filed and that that there's no question that that was properly filed with the court.
Yes, Justice Lukert, and
I have a file stamp copy of.
I don't know, I don't want to take your only copy or anything, but it might be that Mr. Shima can, we might get a copy before you leave the building, if you don't mind, if you both agree. We probably have it, but we're still back where the district courts were very early with our cybersecurity attack, where we're still saying, we all know we're here, but could you help us with the paperwork that gets us here? So we still have a little bit of that going on occasion.
Yes, I think we both agree, and my copy is file stamped as well, but it's annotated, so I can't offer it to the court. But that it was filed as part of the joint notice of no exceptions. And so if there was some confusion, we'll make sure the court gets a copy.
Okay, thank you. Anything else from anyone? Thank you very much. With that, we thank both counsel and respondent for statements and arguments today. That does complete our docket, and the court is now adjourned. All right.